Hello and welcome to this talk that I'm giving on behalf of the Scottish Law Agents Society, of which organisation I am the secretary. But I'm not talking to you in that capacity, I'm talking to you in my capacity as a solicitor advocate who has been involved in litigation for 35 years. And it's in that capacity that I'm talking to you, and I hope to give you some information and some useful guidance this evening, or whatever time of day it is when you're watching this. It's evening at the moment here, and I hope to give you some useful guidance on the subject of written pleadings. Now, this talk is loosely based on another talk that I gave earlier in the year to the Society of Solicitor Advocates, but there's more to this one. And in particular, when I gave that talk to them, the Inner House hadn't yet released its judgment in the case Ahmed versus Ahmed, which is a really interesting case for the purposes of this talk. And that only came out in August, which is a couple of months ago. So I will be speaking to you for the next while on this topic of written pleadings, and in order that I can do that usefully, I'll need to perhaps bore you a bit with something of my own background in this area. When I said I'd been doing this for 35 years, I'm not saying that because I'm boasting about how much experience I've got. It's simply that I remember the system as it was then, and it's useful. I find it very helpful. I think it's fascinating actually to see how litigation has changed over that period, because it has changed quite significantly, and I'll deal with that in the course of this talk. I am hoping and praying that this is recording successfully. I attempted to record this talk last night and spent quite a while on it, and then discovered that it wasn't recording properly. So I suppose I have to treat that like a rehearsal for tonight. So what I'll do is I'll say something about my own involvement with written pleadings over the years, and just try and explain why I think that's useful and relevant and pertinent, and maybe give you a few tips on what I think are important matters. And I should emphasise that although I've been doing this for so many years, I'm not saying that I am any more knowledgeable than anyone who's watching this. I'm not saying I'm any better than anyone that's watching it. I'm just saying that I've got years of experience under my belt, and I've seen how it's done well and how it's done badly, and combinations thereof. So by way of sort of an introduction to this, I conducted my first debate in the Sheriff Court in 1991 before the late Sheriff Archie Bell, QC, and my first proof was in 1992, the year after that. And as far as the debate's concerned, I can tell you that I've seen a great many changes over the last 30 or thereabouts years in how courts have approached written pleadings. And in particular, in the early 1990s, so this is before the introduction of the 1993 rules in the Sheriff Court. So in other words, this is before you had options hearings, Rule 22 notes, and so on. In those days, the presentation of a case was pretty well left up to the agents or the parties or counsel, and there was far, far less Shrivel intervention in those days than there is now. And in those days you were essentially left to get on with it, and sheriffs just didn't really interfere that much. And some would say that was a good thing. Probably more people would say it wasn't a good thing. There were certain defects with that system. In particular, cases were all treated in the same way. Types of case were all treated in the same way. So, for example, a case involving contact to a child would call in the ordinary court next to an action about a personal injuries action, a boundary dispute, a dispute about supply of goods, or a building contract, or something, or a commercial action, or something of that nature. They would all call in the one court, and they would all follow the same procedure. And in all those cases, there would be this Shrivel laissez-faire approach, whereby they just left the agents to present the cases in the way that they wanted to. And I don't really think that was a great system, and it was felt at the time as well that there were drawbacks with it. It wasn't efficient. There was a lot of delay. There was a lot of faffing around, a lot of procrastination. And the way it would work in those days, before they brought in the 1993 rules, which came in 1994, but before those times, a case would call in the ordinary court. It would table, as it was called. The case would table. There would then be a period of whatever it would have been, 14 days, I think, for defences. It would then call on the adjustment roll, the continued adjustment roll after that, and it would probably trundle along there for a few callings, and then the sheriff would, probably after about 3 or 4 callings, would say that enough time had elapsed, and he or she, probably a he, because certainly when I was appearing in those days, there were only 2 female sheriffs out of 20 or more in Glasgow. Shall we say he would then close the record, and at that point the parties would be asked whether they wanted to fix a proof before answer, or a debate. And most times, nearly all times actually, you would have a debate fixed. And the sheriff would never, in my experience, the sheriff never looked into whether or not that was a good idea or not, or whether there was merit in it. In other words, you were not required to explain or justify why you wanted a debate. If you wanted a debate, you would get a debate. Sometimes the sheriff would say, I remember the late Sheriff Brian Lockhart saying to me once, "I don't understand why you're looking for a debate in this case." I was appearing as a local agent, and I think I said, "Well, that's what I'm asked to do." So I didn't even know myself why I was looking for a debate, but I got a debate. And that was the way it was in those days. And unfortunately, 9 times out of 10 debates would go off. They would go off because someone wanted to amend, and they'd be allowed to amend, and then the case would trundle along on the procedure roll until the sheriff had enough of it and said, "I'm not letting you continue this any further." Record would be open, amended and closed, and then you have probably another debate. And this was extremely common in those days, and it was felt that things had to change. So they did change. So they brought in the 1993 rules. They introduced the concept of a Rule 22 note and options hearings, and for a while sheriffs were more proactive at options hearings, certainly in Glasgow. But of course, old habits die hard, and after a while sheriffs were not, in my experience, not generally that proactive at options hearings. Part of the problem, I suspect, was that there was a resourcing issue. They didn't have time to look properly at dozens of records, dozens of processes. So, and that's not their fault, obviously, but the system, whilst there were still debates being fixed needlessly, it was nowhere near as bad as the previous system, so it was an improvement. The big change, I remember when this came out, it was the Coulsfield report, and that came out, when would that have been? Probably, I don't know, maybe the late 90s perhaps. I don't know when the Coulsfield report came out, but I remember it coming out, and it was in relation to personal injury cases, and that report highlighted a lot of sort of, not exactly abuses, but a lot of flaws in the system. The fact that pleadings were far too technical and elaborate, and proofs were being fixed that would go off, there was debates being fixed needlessly and all the rest of it. And it was decided that it was appropriate to have simpler pleadings and try and have some degree of case management and more intervention from the bench as to how a case would proceed, how it would be presented, and how it would be disposed of. So in personal injuries cases, Court of Session was changed in 2003, and they brought in specific rules to deal with personal injuries claims, and the Sheriff Court went the same way 6 years later. And what then happened was personal injuries cases were treated as a sort of breed apart. They were taken out of the ordinary court. They were given a timetable at the outset, which was completely at odds with what had been happening before. And because under the pre-94 system, you never got a timetable. All you would know is when case was calling next, and then the sheriff at that hearing would then fix it at the further hearing. So there was never a timetable. So the idea of getting a timetable under the new rules concerning personal injury claims was actually quite revolutionary, and I think it was a good idea. I really do. I think it was an improvement, a huge improvement on how it had been before. So one of the things that they decided was that there was too much game playing by lawyers, and I don't just mean counsel. I don't just mean solicitors. I mean generally lawyers were regarded as treating the whole adversarial process as a bit of a game, a bit of an exercise in trying to score points off each other, and it was felt that sight had been lost of the purpose of the exercise, which is of course to serve the clients, to serve the public, not to keep solicitors and counsel in a job, or to give them an intellectual exercise. It was, it was felt that wasn't the right priority. So in common with this, sheriffs and judges were becoming less tolerant of litigation and written pleadings in particular being treated as a bit of a game, and it was felt that debates in particular were quite often simply a waste of time, and that unless there was a significant point, something major, something like, well, a time bar point or something like that, or an argument about jurisdiction, or a major point of relevancy, then you'd be better off just fixing a proof before answer. And that's generally what happened. Now, by way of contrast, in the rules I've been talking about, of course, apply only in the Sheriff Court, and the Court of Session carried on much as before, subject, of course, to the Coulsfield report changes being implemented. But as regards sort of standard actions, it carried on pretty much on the same basis that when a record closed, parties were allowed a debate if they so wished. And the case that I mentioned before, the case of Ahmed, is a really interesting one as regards that point. And you should definitely look at that case. I've only seen it on the Scottish Court's website. I don't know if it's reported in session cases or SLT or Scottish Civil Law Reports. I don't know. But it is there on the website for Scottish Courts and Tribunal Service. Its neutral citation is Sadiq Ahmed against Kamal Ahmed, 2024, CSIH, Court of Session, Inner House, 25. And that case was about, well, it was an action of reduction, an action for reduction of a grant of confirmation. Now, as you'll appreciate, one of the many changes brought about by the 2014 Courts Reform Act was that it's now competent to bring an action for reduction in the Sheriff Court. But there are certain exceptions to that, and a grant of confirmation is treated essentially as an interlocutor of the sheriff. So if you want to reduce a grant of confirmation, you cannot do it in the Sheriff Court, because then you would have one sheriff reducing an interlocutor of another sheriff, or even the same sheriff. But in any event, it needs to be done by someone higher up the hierarchy, as it were. So an action for reduction of a grant of confirmation still has to be brought in the Court of Session. And that case that I've mentioned, the Ahmed case, was such a case. So the pursuer brought the action in the Court of Session, and when the record closed, there was a disagreement on further procedure. The pursuer was looking for a proof before answer. The defender was seeking a debate. Now, if you seek a debate in the Court of Session, rather than the court saying we're fixing a debate, they'll say we'll send it to the procedure role. Procedure role in the Court of Session is where the debates happen. And in that case, the defender was looking to have the case sent to the procedure role for debate. There was a plea of all parties not called, and there were issues of relevancy and specification. And so there was a dispute between counsel for each party as to the future fate of the case. Now, in that scenario, what happens is it goes to a role called the by order adjustment role, where the court hears the parties and then determines what happens next. However, what invariably would happen would be that if somebody wanted a debate, then they would get a debate. So in a way, it was like the old pre-94 system in the Sheriff Court. And what's interesting about that Ahmed case is that the normal practice was not followed, and the remarks that were made by the court are really interesting in that one. And in particular, the Inner House had regard to the annotations which are there to the rules of the Court of Session. And the annotations said, amongst other things, that where parties disagreed about where a case was to go, once the record had closed, it would go to the by order role. And there was a statement there in the annotations which says that the practice is that if someone wants to debate, then that's what they get. Now, the Inner House, basically, what they said about that was, they said that the note reflected, and I'm quoting here, the practice generally adopted in all civil actions prior to the trend in recent years towards active judicial management. In other words, the note that said that you get a debate just because you want a debate was reflective of a practice that had been there, well, forever, I think. And they said, the Inner House said that although express provision had been made in the rules for particular kinds of action, and in particular commercial actions, personal injury cases and family actions, they said, and again this is a quote, no such express provision has however yet been made for ordinary actions. And they had regard to a case from 2007, the name of which is Devlin versus the Chief Constable of Strathclyde Police, which is reported at 2007 CSIH, Court of Session Outer House 103. And what had happened in that case had been that the Lord Ordinary had allowed a proof before answer on somebody's motion, whereas the other party had been looking for a debate on the procedure rule. And the appeal point was that the Lord Ordinary had no discretion to refuse a debate if the party, it was the defender in that case, if the defender wanted it. And that case, that Devlin case, was reflective of the practice that was prevalent at that time and was assumed by everybody to be the practice even now, or at least until the Ahmed case in the summer there. And in the Ahmed case, the sheriff, the Inner House rather, said that attitudes have moved on, and that, again, this is attitudes have moved on is a quote, but so is this. It can no longer be said that it is the invariable practice to send a case to the procedure rule solely on the insistence of one of the parties. And they then went on to say that where the judge considers that there's no issue for debate and that insistence on one is a dilatory tactic, the Inner House held that there's nothing to stop the Lord Ordinary refusing to assign a debate. Although they did say that, they kind of suggested that should be done with care, and that there should be full notes and submissions before the judge could make that decision. But it's a real milestone, that case, because it's an indication from the Inner House that the Outer House does not, the Lord Ordinary does not require to assign a debate just because somebody wants one, and that there is a discretion even though there's no specific provision for that in the rules, which of course makes them different from the peculiar rules that apply to commercial actions, personal injuries and family cases. So it's a really interesting development, this, because what it tells me is that the Court of Session has basically moved now in 2024 to the position that was introduced in the Sheriff Court 30 years ago in 1994. It's a really interesting point, because the whole notion of being entitled to a debate in the Court of Session was really entrenched. Another case that's quite interesting on that one is a case called Fairbairn against Vayro, Vayro, a case from 2000, a decision of Lord Osborne, and he was very reluctant to refuse somebody's motion for a debate. The language that he used was quite extraordinary. He talked about, depriving the party of the right to a debate would be improper, illegitimate, extraordinary. So that was, when did I say that was? 2000? So that was the view then, but it's certainly not now. And I think that's a really interesting development that there's been. And it kind of, as I say, it kind of brings the Court of Session more into line with the Sheriff Court. Although there is still a difference as regards Rule 22 notes, because, as you may know, Rule 22 notes, notes of argument in support of preliminary pleas, are governed by Rule 22 in the Sheriff Court. They're also governed by Rule 22 in the Court of Session. It's just coincidence. That happens to be the same number. But there are major differences insofar as you'll appreciate, in the Sheriff Court, you don't get a debate. Your preliminary plea is repelled at the options hearing unless there's a Rule 22 note. Whereas in the Court of Session, it doesn't work like that. You don't have to lodge a note in advance of the point at which the court fixes a debate or proof before answer. You lodge the Rule 22 after that. You lodge it before the debate. And in fact, it's a really interesting distinction as regards procedure in both courts in respect of proofs before answer, because in the Sheriff Court you can't have a proof before answer unless the preliminary plea has been reserved, and it cannot have been reserved unless there's been a Rule 22 note lodged. Whereas in the Court of Session, you can have a proof before answer and there's never any Rule 22 note lodged. And that can be a bit of a problem. I had a proof before answer in the Court of Session where the opponent's preliminary pleas were reserved, and I had a bit of a job trying to find out from them why they wanted to reserve their preliminary plea. You don't really want to go into a proof before answer without knowing what the other side's preliminary points are. As it turned out, there weren't really any in that case of mine, but I was a bit concerned about it, in case I'd missed something and I was going to be ambushed, but it didn't happen. Anyway, getting back to the way in which the courts treat written pleadings. There is now more judicial intervention, which is a good thing in the sense that it should at least focus the case on the major points rather than on the rhetorical discourses that we lawyers unfortunately can be prone to indulging in. And it should make things a lot more streamlined, efficient, and less expensive for everyone as well. And obviously that's really important from the client's perspective, also from the point of view of the public purse. You want things to move along efficiently and quickly. And debates on pleadings, they just hold things up. So I think we are moving in a really good direction as regards this. As regards written pleadings, though, they are still really vital. It's important, really important, that you get them right. So I will now move on to explore some issues arising from that, and in particular, just some ideas that I'm going to throw out there. This is just a sort of collection of points that I've come to, conclusions and opinions that I've come to over the years. And you may think some of them are better than others. You may disagree with some of them. You may think, some of them are stating the obvious. Some of them are nonsense. I don't know. Well, I hope you don't think they're nonsense, but you might. I don't know. So, the first thing I want to say is, as with any legal work, excuse me, let me have a wee sip of this. as with any legal work, whether that be criminal work, conveyancing, executory work, family disputes, neighbour disputes, whatever it happens to be, you always have to cover your back. And that's a consideration which is even more important these days than it was 30 years ago. Because in my opinion, the risks of complaint are higher now than they've ever been. And that's due to a number of factors. I won't bore you with my views on all this because I've probably expressed them elsewhere, but I think we have a complaints culture now. I think that people in the public generally have a low regard for professionalism. They tend to regard solicitors as a bit of an easy target. They can complain at the drop of a hat to the Scottish Legal Complaints Commission and it costs them absolutely nothing. They have nothing to lose by going to the SLCC. They know that lawyers are busy people who do not wish to be tied down dealing with the minutiae of a complaint, even a frivolous complaint. And a lot of them, I think, know that they'll get something knocked off their fee. And it's an unfortunate factor of modern practice, but I think a lot of clients can be quite fly when it comes to this. And you're end of your fee note, next thing you've got a complaint and you find yourself modifying your fee because it's the economical thing to do, but it's not the right thing to do unless it's a valid complaint, of course, but I suspect a lot are not valid. So be mindful of these risks of complaint and always cover your back. Always err on the side of caution, risk manage, and be aware of the dangers of malicious complaints coming down the track at some point. Having said all that might sound as if I'm bitter and hostile towards clients. I'm not. And at the end of the day, I recognise that we're all here doing this job because we're serving the needs of clients, of the public. And part of the reason why the courts have been less tolerant of legal and technical legal arguments in the courts is that they recognise, as we must all recognise, that the court system and the legal system is there to serve the public. It's not there to serve lawyers or judges or the legal establishment. It's there to serve the public. And we always have to have regard to how the public sees us and sees how we do things. And if they think that some of the practices that we follow are antiquated, anachronistic, inefficient, lacking in awareness of technological advances, for example, then we are fools if we ignore those opinions, because there may well be some merit in a lot of what's said. So, turning to the question of written pleadings, you have to have regard to what the client thinks the written pleadings are there for. I mean, after all, you're getting paid by the client to write the pleadings. So, the customer isn't always right, but, at the end of the day, they're the ones paying our wages. They're the ones who are keeping us in work. So they have to know what they're paying for and what the purpose of the written pleadings exercise is. Bear in mind it's your client's case. It's not your case. You're just the agent. And, things can go wrong for us as agents. We can get the complaint. We can get the unpaid bill. We can find ourselves having to chase for fees and reimbursement of outlays and so on. And it can all be a real hassle and inconvenience. But at the end of the day, clients are facing a lot worse than that if they lose an action. A client could be facing the loss of his or her job, kids, house, livelihood, and there can be a great deal at stake. Even in low value cases, people can get very upset if they lose, and it can cost them a lot of money as well. So you can understand why people do get upset. Litigation is inherently stressful for everybody. So, we have to have that in mind as well. So what I'm getting round to saying is that you should try and explain to the client, well, you shouldn't try to explain, you should explain to the client what the purpose of the written pleadings is. And, what you would say is that you're setting out the legal basis of the claim, you're giving fair notice to your opponent of the facts that you will be looking to prove by way of leading evidence at the proof stage. If those facts are in dispute, obviously if they're not in dispute, you're not going to have to lead evidence about them. But if they're in dispute, then you will have to do so, and you have to give fair notice, not of the evidence that you're going to lead, but of the line that you'll be pursuing and the areas that you'll be looking to cover. Some clients, they don't really understand that there's a structure to these things. They think it's just a question of turning up in court and having a fight about things. They don't understand that there has to be a structure, there have to be rules, and that part of that requires written pleadings. So you have to explain this so that they know what you're doing and why they're paying you to do it. Bear in mind, clients are not going to be terribly interested in the technical side of things too much. They're not really either going to be interested in your skills as a written pleader. And bear in mind too, they don't know how good you are, really. They'll know how good you are at returning phone calls or listening to them or communicating with them or something like that, things of that nature. But you might be the best, you might be the most fluent, articulate pleader in Scotland. They won't know that because they don't have anyone else to compare you to. So when I say I've been doing this for 35 years, the client's really not interested in that. They don't really care whether I've been doing it for 35 years or 5 years or 5 weeks. As long as I can put together a set of pleadings that are adequate, then that's all they're interested in. So look at things from the point of view of the client. They want you to do your job. They want you to do it quickly. They want you to do it inexpensively. They don't want you to spend hours putting together a sort of polished work of art, work of literature. They just want you to do what you have to do to get the case to the next stage and get it over the line and hopefully win it for them. So literary skill really doesn't matter to clients. What does matter though is keeping them informed about what's going on. So you do need to make sure that it sounds obvious, but you have to let them see the pleadings. After all, you're doing it in their name, so they need to see what you're putting forward to the court and to the opponent on their behalf. And therefore you should always, unless there's an absolute emergency, you should always send the client a copy of the proposed pleadings, whether that be the writ, defences, adjustments, or probably not submissions, but then I probably would. After all, why wouldn't you? There's really not anything that I can think of that you wouldn't send to the client. And of course, it all goes back to what I said earlier about covering your back, because once you've sent the pleadings, and it doesn't matter what the pleadings are, once you've sent them to the court or to the other side, they're then part of the record, as it were. Not necessarily the record, but the record of what's out there. So before you do that, before you take that step, you need to make sure the client's on board with it. So always make sure you run it by the client before you send it to anyone else. The other thing I would say is that, written pleadings, they can be a chore, they can be a bit of a nuisance having to do them, but on the other hand, you need to look at it positively. I try and treat a drafting exercise as a bit of a checklist, and to my mind it helps focus the mind on what's required down the line in terms of the evidence that you'll need, for example. So, I had a case involving a horse which was afflicted by numerous ailments, which I was able to Google. So I was able to work out roughly what these involved, but I'm not a vet. So, I knew that I would have to adduce evidence concerning these equine ailments. And the exercise of actually drafting the pleadings, threw up these issues that I knew I would have to address. So it prompted me then to go in search of someone, an expert, who could give evidence in due course as to the nature and the consequences of these ailments. So treat drafting as an important checklist, and treat it as a useful warning almost as to what you will need to deal with later on down the line. If you are, as I said earlier, that you're drafting and you're submitting pleadings on behalf of a client, which obviously you are, but what you have to also remember is that it's your name that's on the document. Now, alright, I get that lawyers don't have to put their names on all documents, but the important ones you generally have to. The writ, for example, or the defences, or minutes of amendment and so on. So it's your name on it, so you have to make sure that you've got some basis for what you put in your own pleadings. And I don't just mean the client's instructions. I mean something along the lines of a precognition, an affidavit, a letter, an email, a text, a report, even a file note of a conversation that you've had. But there needs to be something tangible, as it were, so that you can justify making an averment. On that subject, let me say something just now about making averments of fraud, because this is something that I've talked about before, and I've had cases involving allegations of fraud, and it's something that I've looked at a few times. My view of it is, and I'm talking about this simply because we're on the subject just now of your name on a writ or defences. Averring fraud is something that you have to be very careful about, and if you do decide that you're going to aver fraud, then you have to make sure that you've got plenty of evidence to back you up, and you also have to make sure that the pleadings are very, very precise as regards the nature of the fraud. If you look at McBride on contract, and the edition I've got is the 3rd edition, which I think might be the last edition. It's getting on a bit now, that one. I wish he would write another version of it, another edition, because the 3rd edition is getting on a bit, but it's still a really, really good book. McBride on Contract, thoroughly recommend it. And in the 3rd edition, there is a whole section on pleading a case of fraud, and the author he's very good on this. He says that there must be specific allegations of fraud. He quotes Lord President McNeill. I must say I don't know that I've come across Lord President McNeill before, but anyway, he's from, when I say that, I mean I'm not sure that I've heard of him. Now, he was around a while ago. He was around the mid 1800s. But anyway, what he said was allegations of fraud render it peculiarly necessary to have directness of statement. That was in a case from 1857. And then there was another dictum from him, I think, from 1861, which says we must know precisely what the things are and what the acts are which are alleged. What was it? ? Did he nod, or wink? Or what was it that led them to believe? Them, I think, must be those who were alleging they were defrauded. So anyway, leaving aside the sort of peculiar wording of that, you can see that there's long-standing authority to the effect that fraud has to be very particularly pled. You have to state what the acts are, the statement that was made, and so on. And of course, I mean, fraud's, it's not always a criminal offence, but it is essentially a criminal act, isn't it? Fraud. And therefore one has to be very careful about pleading it. My view, my approach is that if you're going to allege fraud, and you'll be relying on it, and if you're not going to rely on it, you shouldn't really be averring it. But anyway, if you're going down that line, you should get more than just I think you should get more than just a text or a precognition or something like that. I think you should get an affidavit. And I think it's that important that you should cover yourself by getting an affidavit, because an affidavit is evidence, a precognition is not evidence. So get the affidavit. The other thing you can do, and I've done this myself, is I've taken a statement from a witness who's alleged fraud, and I've also had a colleague independently and separately precognose the same witness. And then you've got, essentially the allegations being made to two separate precognosers. And again, that covers you down the line when you then make those averments. I had to put it once in a proof. I had to put it to a solicitor, an English solicitor. She was from Sheffield. I had to put it to her that she had fabricated a file entry, and it's really awkward doing that. Really, really awkward. But if you have to do it, you have to do it. I remember also in a road traffic case having to put it to someone that he was not in a car. My client was absolutely adamant that the car with which he had collided had only one person in it, namely the driver, and the alleged passenger in that car was completely fictitious. And that's a case where you have to be absolutely, completely certain in your own mind that the client is clear that there's no room for mistake, and that there's skullduggery there, jiggery pokery. And I lost that case, by the way. But anyway, if you have to put these points forward, then you have to put them forward. But the Law Society actually has a rule about this, and it's Rule 4433, and it says you may not put to a witness any question suggesting that the witness has been guilty of a crime, fraud, or other illegal or improper conduct, unless you have personally satisfied yourself that there is evidence which could, if necessary, be led in support of the suggestion. Now obviously that's to do with questioning a witness, but the same precautions I think apply when it comes to making written pleadings of fraud. You've got to have some evidence, and an affidavit is evidence, so make sure you get one, I would suggest. So fraud. How did we get onto this? We're talking about yes, the need to have something concrete before you make written pleadings. So moving on, as I said, you should always send your client a copy of the pleadings before you commit them to the other side or to the court. Now, I should add that I'm not one of these solicitors that takes kindly to being, told by clients how to do my job. Particularly with matters of style. I've had clients who've said, rather than putting it that way, could you put it this way? And you think, no, I don't want to put it that way. I want to put it the way that I put it the time that I showed you it. I don't want to change it. Because it's one thing, if you get the facts wrong, then obviously that's no use. You want to be corrected about that. If you put in that a car crash happened in July when it happened in February, then clearly you want that to be brought to your attention as soon as possible so you can put it right. But matters of style, I think, should be left to the solicitor. And I just don't like clients telling me how to write letters, how to do pleadings and so on. It just annoys me. But if people are going to get really upset about it, I suppose you would change it a bit. But I can't help feeling a bit resentful when I have to do that. Anyway, get some sort of consensus with the client as to what's to go in, and make sure it's agreed, and then you can send it to the other side. Because remember that if you get something wrong between you and the client, then alright, it can be awkward. He might think you're an idiot or sloppy or whatever, but it's not the end of the world. It can be put right before any damage is done. Whereas if you commit it to the court or intimate it to your opponent, then it's out there, and it always will be out there. It's a bit like, it's a wee bit like a power of attorney. If you draft a power of attorney and you've got a mistake in the spelling of somebody's name, like say it's McEwen or McCartney, and you spell it with an MAC instead of MC, or McEwan instead of McEwen, whatever. There's a multitude of things that can go wrong. You send it to the client, they'll check it, hopefully spot it, and then they'll say to you, you've misspelled McEwen or McCartney, and you can put it right before you send it to the OPG. If, however, you've sent it to the OPG and it's registered and it comes back with a mistake in it, it's really difficult to get that changed. In fact, you can't get it changed. You have to go through all the palaver of revoking it and then granting another one, with the only difference being the correct name. So it's a complete hassle. But the point is, there are different consequences of an error depending on the stage at which it's made. And if you catch these things before, and when I'm talking about written pleadings, if you catch them before they're actually sent away anywhere, then the damage can be quite limited. You have to remember, you see, that once you've put an averment into a writ or into anywhere, into defences, into a minute of amendment, if that case then goes to proof, then anything that's ever been in the pleadings is fair game for cross-examination. So it's not just what's in the closed record, it's whatever's been in the pleadings at any stage. So if your original writ states that a conversation took place in January 2023, and then by adjustment you change it to say that it was actually in April 2023, then although the closed record will say April 2023, your client can still be cross-examined on why he or she said originally that it was in January of 2023. And that can give rise to awkward situations. I mean, broadly speaking, when the client is asked about that, when it's happened to me, when I've seen it happen, quite often the client won't understand what the point is. So they'll have to be referred to the writ or whatever it is, and then the eventual pleadings, and asked to explain the discrepancy, and usually that takes a while, everyone having to look at the pleadings, the sheriff having to do it at the same time as the witness. And clients quite often really don't understand what the point of that is. And the answer will eventually be something along the lines of, well, I got it wrong. There was a miscommunication, or worst of all, my lawyer got it wrong. And it's always an embarrassing situation when that happens, you know, because essentially you've got a conflict there, or you might have. Whatever the explanation, you know, it's not a good look. And courts will assume, I think, that parties have at least seen their own pleadings before they have been sent to the court. And on that assumption, they will proceed on the basis that the client got it wrong. And unfortunately for the client, that can undermine the client's reliability. And that can, you know, jeopardise the case for them. Maybe not in a huge way, but nevertheless, if it happens at all, it's not good. So, you know, it's something that might make its way into the judgment. And if your client loses a case, and you know what clients are like, you know, they'll lose a case, they'll immediately try and find some way of blaming you. So they'll scour through the judgment and they'll see that Mr. So-and-so said in his original writ that something had happened in such a way, and then by the time of the closed record it was someone else. And the client will focus on that. They'll blow it up out of all proportion and say, you know, it's your fault, and that's what cost them the case. You know what can happen. So again, it just goes back to covering your back. Try and avoid getting into that kind of situation. And it also helps the client as well, because these inconsistencies, not only can they lead to, you know, complaints about you, but they're not helpful to the client either. So just be careful about what you're pleading. Be careful that, you know, you've got your clients okay with it, and that there's consistency. On the subject of who pleadings are aimed at, I know that one of the purposes of written pleadings is to give your opponent fair notice of the evidence that you're intending to lead, or the submissions that you're intending to make. But you have to take account of the fact that the person who is going to throw out your case or stop you leading evidence of something important is not your opponent, but the judge or the sheriff. And therefore you have to think to yourself, is this writ going to be sufficient to satisfy sheriff whoever that the case can proceed to the stage that you want it to proceed to? And that leads us on to another matter, which is the necessity of knowing your judge or knowing your sheriff insofar as you can. We all know that some sheriffs are more demanding than others. It's human nature. Nobody's, people are not all the same. Everyone has their own quirks, traits, faults, call them what you will. Some sheriffs are more pernickety than others. That's just reflective of human nature and society. But from a risk management perspective, you have to kind of work your way through that. And I know that it's not unknown for solicitors to take account of who their sheriff is likely to be and to modify matters accordingly. There is a thing called forum shopping, whereby you try and control who your sheriff is likely to be. Now, I know that this used to happen in Glasgow. Quite often you would be instructed to obtain an interim interdict at a pre-service stage. So what you would do is you would check the court sheets and you would see which sheriff was down for which day, and I can't possibly name anybody, but I'd love to, but I shouldn't, or so I won't. But you would find that a particular a difficult sheriff was hearing pre-service hearings on the Monday. So I would be doing it on behalf of other firms. So you would speak to the firm and you'd say, listen, that sheriff is quite likely not to grant this. However, on the Tuesday, it's a different sheriff and he or she is likely to be far more amenable. So they would say, well, just wait 24 hours, put it in front of the sheriff on Tuesday. And that's what you would do, and usually you would get the result. I mean, it's a bit like intermediate diets. I don't do criminal work anymore. I never really did much, but I know plenty of criminal lawyers, and I know that they would, recommend to clients either to plead or not plead at intermediate diets, depending on who the sheriff was. So some sheriffs, I remember a particularly difficult sheriff saying to me that he thought intermediate diets were a waste of time because nobody ever pled at them. And I didn't say to him, but I thought to myself, well, nobody pleads at intermediate diets when you're there, because he was a really heavy hitter, really heavy sentencer. Whereas the softer sheriffs would find that pleas would be more prevalent in their court. So the point is, it would be daft, it would be artificial to ignore your sheriff, to who the sheriff is. And you have to factor that into how you proceed. I mean, it can also operate, sometimes of course you have a choice over which court you want to litigate in, depending on what kind of matter it is. If it's a consumer contract, you can either litigate, of course, in the if you're the defendant, if you're the pursuer and you're the consumer, you can litigate in your own court, or you can litigate in the business's court, the opponent's court. Divorce cases, you can litigate in your, the court of your jurisdiction, your domicile, or that of your opponent. You have the choice, and it may be that you think you'll have an easier time in one court than in another, depending on who's there, and that might influence how you where you raise the action. It has affected me. I've personally raised an action in a particular court because I've thought, it'll be an easier ride in that court because of who the sheriff is. So, nothing wrong with doing that. You're just serving your client in the best way that circumstances allow. If you remember the Johnny Depp Amber Heard case, I read somewhere that was raised in, what was it, Delaware? Was it Virginia? Whichever court it was a court in which cameras were allowed, and I believe that the pursuer thought that that would put more pressure on the defender to settle. Whether that's true or not, I don't know, but these tactics are not unknown in litigation. So that leads me on to the next point, which is knowing your sheriff. Now, I've already mentioned about knowing your sheriff and trying to take that, bring that to your advantage. There are certain types of procedure where these things can be more important than others. So the example I have here is commercial procedure. The commercial rules are quite loose insofar as they do give the presiding judge or sheriff a fair bit of leeway over how he or she decides to want a case presented. And McPhail, have I mentioned McPhail yet? McPhail, I've got it sitting here. This is a must-have if you're litigating either in the Court of Session, by the way, or the Sheriff Court. This is the 4th edition. This is edited by Sheriff Cuby when he was still a sheriff. He's now a judge, but he edited this. And this is the 4th edition from, I think, 3 years ago, 2021. This is a wonderful book, absolutely wonderful book, and I don't know how anybody could litigate in the Sheriff Court without that. And indeed, I think it's a great book for the Court of Session as well. Unfortunately, there is no equivalent of that book for the Court of Session. The Court of Session procedure books that I've got are all really old. The one I use most often is McLaren, which I think is at least 100 years old. I think it's from the 1920s? I think it might be. So there's also Maxwell. What else? There's one by somebody in Middleton, which I've got somewhere. There are, but McLaren's the best one in my opinion. And it's useful for the Sheriff Court as well, because of course there are a lot of concepts and practices that are common to both courts. So for example, if you've got a case in the Sheriff Court concerning cation for expenses, right? Well, there'll be something about that in McLaren, and equally, if you're in the Court of Session and that's the issue, there'll be something in there in McPhail about that. And the law on these things is the same regardless of the forum. It's not a different set of principles that apply to cation for expenses in the Court of Session as opposed to the Sheriff Court. So how did I get on to talking about this? Yeah, McPhail. It's a great book. And McPhail says something about the commercial rules and says, this is at 2518, each sheriff, he's obviously talking about commercial procedure in the Sheriff Court, each sheriff will have an individual approach to such issues. That's the issues in the case. And should the view of the sheriff dealing with the action be unknown, it's probably better to defer a decision on how detailed factual material is to be presented to the court until the first case management conference, when the issue can be discussed. And the chapter suggests that, for example, Excel spreadsheets might be the best format in which to present issues of fact, rather than averring them at length. So the point about that, I suppose, is that some sheriffs will want you to present the facts in a way that they prefer, and if you're not quite sure what that way is, then you're better finding out before you embark upon the process, rather than wasting time and maybe having to do it all over again in a different manner. So that's the advice in relation to commercial procedure. As regard, we were talking earlier about clients and about explaining to clients what pleadings are for, and I was also saying that clients will simply want you to produce a set of pleadings that's adequate to get you through the case. It's also worth pointing out that clients will assume that the sheriff who hears the case is a better lawyer than you are. Right? Clients, not all clients assume that, by the way, but a lot will assume that. So, if you put that in context, let's say you have a case that goes to debate, and your opponent has a preliminary plea directed at your pleadings. Say it's that they lack specification, and at the debate you say to the sheriff, I disagree that there's a lack of specification, there's sufficient specification to give fair notice, please allow this case to go to a proof, or a proof before answer. Now, you know yourself how this works. In that situation, the sheriff, if he thinks there's a lack of specification, he will not immediately throw the case out, but he or she will drop really heavy hints. And I've noticed over the years they've got heavier. And at one time you had to be quite perceptive to pick up the facial expressions and the mannerisms, but now things are a lot more obvious, in my experience. But the sheriff will drop heavy hints that he does think your pleadings are lacking specification, and you're then put in a bit of a dilemma. What do? Do you take your chances and say, I'm sticking to my guns, I'm satisfied that these pleadings are adequate, there's sufficient specification, I'm not going to do anything about it, I'm going to just let the court decide? That's one option. The other option is, you take the hint and you play it safe, you move to discharge the debate, you seek leave to amend, and you go away and you beef up your pleadings. Now, you've got the choice there, you don't have to do one or the other. Going for the seeking to discharge and amend is usually the wisest course, in my experience. I mean, after all, why take the risk of the case getting, because it will get bombed out if you let it go the way, and the whole way, and the sheriff has to issue a judgment. Or at least, if it doesn't get thrown out, you could find that large parts of your pleadings get excluded from probation, and you're then handicapped as regards the proof. You really don't want that happening. And then what do? If your case gets dismissed, or your case gets mauled by the sheriff, and you find yourself with limited pleadings, what do you do then? Do you appeal? You could do, but if you appeal, you then get embroiled in the whole procedure in the sheriff appeal court, which in my experience is very cumbersome, or it can be very expensive, and it's just not a great experience going to the sheriff appeal court. In my own personal experience, it's not. I much prefer it going to the sheriff principal, but I'm showing my age there, I suppose. The point is that you may take the view, despite having sought leave to appeal, that you are still right, that there was nothing wrong with your pleadings. The client, however, will think you've got it wrong and that the sheriff was right to think there was a defect there. So I suppose what you have to do is you have to just say to the client, the sheriff and I are both lawyers, we're both familiar with court work, we're both familiar with pleadings, and we will there could be a legitimate disagreement. That's not to say that I'm wrong, that the sheriff's right. It just means that there's a disagreement, and in the system within which we operate, it's the sheriff's opinion that matters. In other words, you don't want the client to go away thinking you're negligent because you've had to change your pleadings when you thought they were fine as they were. So again, I suppose it's a question of communication, isn't it? Going back to the question of the client, remember that what you're there to do ultimately, not just in the ordinary court where pleadings are more important than elsewhere, but in any kind of court action, summary cause or simple procedure or whatever, the purpose of you being there is to get an effective remedy for the client. So make sure that you cover all the angles there. Make sure that you get yourself a remedy that will actually be of benefit to the client. So for example, if you're looking to recover tangible property, or heritable property for that matter, make sure you get authority to open, shut and lock fast places. If it's a car, if you're trying to recover a car, for example, don't just get an order for recovery of the car. Make sure you've got an alternative crave for payment in case you can't recover the car, in case the car's vanished somewhere. Make sure that you've got a crave for sheriff officers to open a locked garage. I mean, what's the point of getting an order for delivery of a vehicle that's in a locked garage when you don't have authority to break into the garage? Because the sheriff officer won't break in unless they've got authority to do that from the court, and they can only have that if you've asked for it. So make sure you ask for all the remedies that you think you might need. In a kind of similar vein, where the court has got some discretion over how much to award, always ask for as much as you possibly can. So if it's a claim for solatium, you would generally ask for considerably more than you think the claim is worth. I mean, everybody does that. There's nothing wrong with that. Because the court can award less than you're claiming, but it certainly can't award more. So aim high, and hope for the best, but make sure that the client doesn't think that that's what he's likely to get. You have to manage the expectations of the client. So you'll say to the client, look, your claim's probably worth £15,000, but I'm going to sue for 30. We might get 20, but we might just get 15. If we do get 15, don't be too downhearted about it, because that's probably what it's worth. Same with divorce actions. We like to think that divorce actions are governed by this very sort of mathematical set of formulae which govern how awards are quantified with regards to certain factors and considerations. But at the end of the day, divorce law, the amount you get in a divorce case generally is up to the discretion of the judge within certain limits. So again, aim high in a divorce case. Turning to the detail of the pleadings, what have I got here? Designations of parties. You have to make sure that this is done as accurately as possible. bear in mind, I've just mentioned there about getting a decree that's useful. You have to make sure you get a decree which sheriff officers or banks or third parties can rely on for the purposes of giving effect to diligence. Now, the law of diligence is a bit of a bugbear of mine. I think the law of diligence in Scotland is woeful, but that's another topic. I might talk about that some other time. But certainly, we have to work with the law that's imposed on us. In the meantime, you have to get things right. I mean, there are things you can do. I mean, making sure you spell names correctly would be one thing. Make sure that people's names are correctly spelt. That if they've got a middle name, that's there. Make sure as well with artificial entities that they're properly described. And with particular regard to limited companies, I always make it my business to check, limited companies on Companies House, and that goes for my own clients as well as somebody that I'm suing or being sued by. It's really easy to check these things. I mean, at one time it was tricky. It was cumbersome to check the exact designation, the officers, the registration number of a limited company, but now it's dead easy. It's really easy to do it. You just go onto the Companies House website and look it up. You can do it in 20 seconds. And you should always do that. I always make sure, if I get instructed by a company, I always check Companies House to make sure that everything's okay, everything's hunky-dory, because bear in mind, if you purportedly act on behalf of a company and then it turns out the company doesn't exist, you're personally liable, because obviously an agent who acts for a non-existent principal is personally liable. And do you really want to be personally liable for anything involved with a court action? Of course you don't. So check that, and make sure you keep checking as well. Check every so often to make sure the company hasn't been struck off, or that it's not been restructured or something of that nature. Quoting the law. I know that a lot of people think you're not meant to quote law, quote fact, aver facts but not law. Now that was probably true a while ago, but nowadays I think averring the law is actually quite a helpful thing to do. I've always thought that. Now, you do it with regards to some things. I mean, for example, jurisdiction. You have to have something about jurisdiction, and quite often jurisdiction is based on the 1982 Act, but quite often it's not. Family proceedings don't rely on the 1982 Act. So, but they usually, in fact, they always rely on some statute. So, quote the statute. And I think that's an obvious thing to do. Courts have got to be satisfied that they have jurisdiction. It's pars judicus to check that. And, you want to try and make things easy. I mean, for one thing, if you've got an action, I had a case recently involving a declarator of paternity, and I had to check what the basis of jurisdiction for that was. And for the life of me, I can't remember what it is, but it's a statute. It could be, I don't want to guess. I can't remember what it was, but anyway, I knew then, which is what matters. So, yes, check your jurisdiction, find out what the basis of it is, and aver it. And there are plenty of other sort of matters that are based on statute. For example, something like an interdict, against domestic abuse. That's all statutory. So, quote the statutes, and that way, it's a useful thing to do anyway, because you're checking for your own peace of mind that you've got the right law before you, you know what you're doing. And also it's helpful to the court, and it also shows that you've looked into it, so they can have more faith in your ability to plead a case if they think you've looked into the law. And in addition, of course, it's helpful to the opponent as well. And I can't think of any downside to that. So don't worry, in my opinion, do not worry about averring the law. You obviously wouldn't quote case law, that kind of thing, but statutes, I don't think there's anything wrong with that at all. Moving along, what have I got here on my list? Yes, one way in which you can try and cut pleadings down is by using the phrase hereinafter X rather than repeating things ad longum. So if your case is concerned with subjects known as informing 36 West Portland Street, Troon, South Ayrshire, KA 106AB, registered in the Land Register of Scotland under title number AYR, whatever it is, you would then put after that hereinafter, open quotes, the property, close quotes, or the subjects, or something like that. And then when you refer to it subsequently, you just call it the property or the subject. And that's a good way of abbreviating the pleadings. I've talked so far about general pleadings and sort of general and ordinary type actions. Do bear in mind, I've mentioned before about commercial proceedings, do bear in mind that some forms of procedure have got their own rules about pleadings. So I think it's personal injuries cases, you don't include pleas in law. I really don't know why that's the case. I mean, why wouldn't you just put pleas in law in? I think you do have to say something along the lines of whether the case is based on statute or common law. And if it's on statute, you have to quote the statute. Well, why not just put that into pleas in law? I don't know. But anyway, all I'm saying is, if you've got an action that's out of the ordinary, whether it's personal injury or commercial or a family case even, check the rules to make sure that what you're pleading is in compliance with the rules. And on that regard, you also have to look at whether there are practice notes. Practice notes, I think, are more prevalent now, are they not? I get that impression. They're more common than they used to be. And you get practice notes in the Court of Session, you get them in the Sheriff Court. The Sheriff Principal will issue practice notes. Some sheriffs will not exactly issue practice notes, but they'll make it known what they expect in terms of styles and what's to be included and what's to be excluded and so on. The status of some of these statements I'm not sure about, but from a practical perspective, have regard to them and just take the path of least resistance and just comply with them, unless you want to have a fight with someone about them. But I think they're generally quite sensible. I mean, I don't like style wars, but on the other hand, we are moving towards, in all manner of legal exercises, we're moving towards standardization, we're moving towards uniformity. So, life's too short to get upset about styles, but that's, as I say, it's not worth getting into an argument with the sheriff over styles. Pleas in law, right? Now, as I say, some types of action you don't need pleas in law, but most you do. What about the plea in law that you've probably seen? And I'll tell you what it says. The defender being due and resting owing in the sum sued for, decree should be granted as craved. Now, you see that one a lot Probably not as often as you used to, right enough, but I mean, what a meaningless plea that is. Basically, that's just saying, because the defender owes me the money, grant a decree for the money. Of course you think that. You wouldn't be raising the action if you didn't think that. I mean, it's such a completely superfluous thing to aver or to plead. On the other hand, does it do any harm? It's a catch-all. It's probably applicable in virtually every case that, any payment action that's ever been raised. Some sued for excessive. That might be a good one to put in as well, and not just in salatium claims. It might be appropriate if you are involved in an action concerning, say there's a pattern of trading and someone's suing for a balance due in relation to goods that were supplied. There might be some issue about whether the goods were defective, missing, the wrong specification, and so on. Some sued for excessive will cover a situation where the sheriff finds that some of the goods that were sued for, weren't supplied or weren't right in some way. So I'm not really sure what my point is about those pleas in law. Just take them into account, have regard to them, but you should always have more specific pleas in law, directed to the particular circumstances of the case. The ones that I've mentioned there, they're kind of general, but on the other hand, they are pretty harmless as well. So maybe it is appropriate to throw them in where that's appropriate, where that's suitable. I've got something here about written submissions. Now, this is something. Written submissions are obviously a lot more common than they were before, and the reason for that is, of course, COVID. Because at one time, before, when was COVID? 2020, was it? Before that, written submissions were quite unusual, although I always thought they were very helpful. But with the coming of COVID, everybody had to change all their systems and practices, and one of the things that happened was that sheriffs started to request written submissions, rather than having people turning up and getting infected or passing on an infection or causing other risks. And they've kind of stuck, written submissions, but I must say I like them. It's hard to generalise when discussing written submissions, because there's so many scenarios in which they can be used. In my experience, they were always quite common after proofs. So, I had a proof last week, and the sheriff finished the evidence after 2 days, and the sheriff directed that written submissions be lodged, and then we've got a hearing thereafter. I mean, that's a good system, and that's not a new thing. I've come across that numerous times in the past, and it's a good way of proceeding, in my opinion. It's common in the Court of Session as well, and it helps you focus your arguments. It saves time at the hearing, because the sheriff's already read the submissions, and if the sheriff's got any questions or any queries, they can be raised at that point. So it's a good system. Of course, they're also used now with motions, and that's a kind of new thing. That never used to happen. But again, it's a good idea, in my opinion. The one thing I would say about it is, though, that the table of fees hasn't really caught up with written submissions. The table of fees is a little bit out of date. It's usually the case, but they're kind of still predicated excuse me, they're still predicated on the notion of turning up and making oral submissions. So perhaps the table of fees needs looked at. Written submissions, as I say, have been around for a while. I do remember that in Glasgow there was a group of sheriffs, including Sheriff Principal Taylor, as he was at that point, they were very keen on commercial procedure. This is before formal commercial procedure was in existence. They were very interested in how to streamline procedures, and they were very enthusiastic about written submissions. And so it's something that has been around in one form or another for some considerable time. But as I say, they're not really accounted for in the table of fees. They're not that well catered for even in McPhail. But as I say as well, it's hard to generalise about written submissions just because they're used now in so many scenarios. Okay, what else have I got here on my list? Okay, how about this one? And it's probably a statement of the obvious, this, but try not to rely on the first draft of a writ. Unless, of course, you are in a real hurry, in which case, you don't have the luxury of being able to go back and revise a writ. I once had a case where a woman got really badly assaulted by her partner, and I had to go and visit her in Glasgow Royal Infirmary and take instructions from her. She was lying in her bed all bruised and injured, and I actually hand wrote a writ and went straight down to the Sheriff Court in Carlton Place and put it in front of the duty sheriff and got the orders granted. And what I remember also about that was she got back with this guy, I think, the day after. Just astonishing. But I went to all that trouble, and I wasn't able to revise it. I know I just had to put it together there and then, literally in the hospital, and then get a taxi down to Carlton Place. But that's an exceptional scenario. Usually you'll have a bit of time, and you should always take advantage of that and go back and check the writ or whatever it is. Just make sure that you're happy with it. Very rarely have I ever not revised a writ that I've drafted. So I'll draw it up and then leave it for a week maybe, or a few days, go back and look at it, and 9 times out of 10, probably more than that, I'll change something in it. The other thing, of course, you can do is run it past a colleague in the office. I mean, that's always quite a useful thing, because quite often, the way you read something might not be the way in which someone else reads it. So a fresh set of eyes can be a useful check on what you've written. Another thing that I would say is that try not to use, if you're drafting a writ, try not to use a handful of condescendences. Try and use, twice as many as you would normally use. If you think about it, if you've got, say you've got 100 lines of text to go into a writ, it's not going to take up any more space, really, if you arrange it in 10 condescendences of 10 lines, as opposed to 4 condescendences of 25 lines. So use many condescendences, because you know that if the action's defended, you're going to be expanding the condescendences, and that will happen. So make sure you've got plenty of condescendences, so that you're not ending up with a situation where you've got a condescendence that's a page and a half long, because it's just not easy to read, and there's no need for it either. So I would suggest try and use as many condescendences as possible. On the other hand, try not to use long sentences. or even sentences with more than one proposition. The master of the short sentence in terms of judgments is undoubtedly Lord Denning, and his style is fantastic in my opinion. His judgments are just so easy to read. He uses sentences that are like 6 words long, and he splits up a sentence that someone else might write that's 3 lines, one sentence, 3 lines. He'll split it up into maybe five or 6 different sentences, and I've tried to, when I've talked about this before, I've tried to illustrate it by just taking a line from, a commonly known line from a song or something of that nature, and just breaking it down into its components. And the one that I saw recently, I think I must have had an old Christmas card in the office, but the one that I saw was this. Right, I'll read it out to you. It's good King Wenceslas looked out on the feast of Stephen, when the snow lay round about, deep and crisp and even. Now, as an averment, that's really not that long. However, there are at least 4 statements in that one line. We have firstly the individual. We've got a description of an activity. We've got a date. Feast of Stephen, by the way, is Boxing Day, I think, 26th December. And we have a description of weather conditions as well. I mean, it's not that different from the sort of averment you would get in a road traffic accident proof case. And if we assume that the king was looking out this window, that's a 5th component as well. Locus. Now, there could also, of course, be a dispute about whether Wenceslas is a king, so that'd be capacity. There might also be a dispute about whether he was a good king. So there's a dispute about characteristic, whatever. But treating that line not as a classic element of a Christmas carol, but as an averment, you can see that there's a multitude of various components, any one of which might be disputed. But it's as an averment, it's quite a difficult one to answer. You might say, if you were disputing the date, for example, you might say that admitted that good King Wenceslas looked out under explanation that he did so on the 3rd of January. Or if you were disputing the weather conditions, you would say admitted that he looked out on said date under explanation that it was mild and sunny. It's all a bit messy. It's all a bit kind of unfocused. But the problem lies in the averment. And the averment could be split into various components, all of which would be quite easy to answer. So, for example, what I've got here is, Wenceslas was king. He was good. He looked out. He did so on the feast of Stephen. On that date, the snow lay all about. It was deep and crisp and even, or even it was deep, it was crisp, it was even. And doing that, breaking it down that way, just makes it easier to answer. It makes it easier to follow. It's not as elegant to read, but bear in mind, this is a writ with averments in it. It's not a work of art. It's not a work of literature. It's not meant to be, poetical. It's meant to be functional. So break it down into its components, and it just makes it easier to deal with. And of course, the one I've read there about good King Wenceslas, that's a really short statement. I've seen averments that are a lot longer than that. And as I say, there's no need for it. It's just a question of reframing it, rewording it, making it easier to answer. Moving on. I had a case recently in which the terms of photographs were incorporated brevitatis causa. And I thought, how on earth do you incorporate brevitatis causa, right, for the sake of brevity, the terms of photographs? I understand incorporating the terms of a document, and it's good sense to do that, but a photograph's a visual image. It doesn't comprise terms. I had no idea how to answer that. So I'm suggesting you don't do that. Or if you are going to do that, you could maybe contact me and let me know how I'm supposed to answer that. So I just mention it because it's something I came across quite recently. Okay, written pleadings. Embrace brevity. Succinctness is a virtue and verbosity a vice. Pleadings inundated with superfluous verbiage not only test the patience of the court, but also dilute the potency of your arguments. Every word should serve a purpose. Every sentence should advance your narrative. Pare down your pleadings to their essence and let the strength of your arguments shine through. Now, that is a part of a statement that I obtained by the use of ChatGPT. ChatGPT, everybody knows about that. Generative AI, we hear a lot about that one, and I think it's a great thing, but you need to be really careful about it. I have to say that what I've just read out there is fine. Nothing wrong with that. It's good. But rather than shunning these things, I think we need to embrace AI. I think it's great, but just be careful with it. In one way, using AI isn't really any different in principle to cutting and pasting from existing styles, or filling in boxes, filling in sections on a pro forma document. It's making use of what's there already. It's good from a time management perspective, I suppose. It's quite efficient, and it's a really interesting idea. But you do have to be careful. You'll have heard probably of the New York attorney called Stephen Schwartz, and he apparently used ChatGPT to prepare a legal document which he filed. So far so good, but then it turned out that the document had cited non-existent court cases. How on earth that happened, I don't know, but apparently that's what happened. And Mr. Schwartz got into a lot of bother as a result of that. So, as I say, nothing wrong with using ChatGPT, but just be alert to the risks that it might pose. I thought I would mention ChatGPT just to prove that I'm not some kind of old fossil, some old dinosaur who's resistant to change. Similarly, when it comes to the use of Latin in pleadings, I don't hold that in any great regard. Some Latin is useful. For example, esto. Esto's quite a good one. That's a good, useful phrase or word to use. But some of them are pointless. For example, et separatum. What's the point of that? You may as well say and separately. It's the same number of syllables, same length of words, more or less. et separatum. It just sounds daft, in my opinion. When I was at school, how long ago was that? 40 years ago. I studied Latin at school. And one of the reasons I did was that I thought it might be useful for my career in the law. And it was to some extent, because there was a bit more Latin around in those days than there is now. So you would have phrases like, for example, vergens ad inopiam, which means verging on insolvency. Reinterventus, which was later superseded by the same thing but in a statute somewhere in plain English. Can't remember which statute it is. But there were various concepts that were phrased in Latin at that time. Not really so much nowadays, but I generally don't think Latin's that well regarded by the courts when it comes to pleadings. I think it's seen as a little bit snobby, a bit elitist, and a bit quaint. So try not to use Latin, I would suggest. The other one I would try and avoid using is try and avoid saying the said all the time. MacPhail backs me up on this, by the way, at 973. He says that the said should be used sparingly. So I think what's meant by that is if you've got a case about a house or a marriage or a car, you don't need to keep saying the said house, the said marriage, the said car, because there's only one. And everybody knows which house, car, marriage, or whatever it is you're referring to. You don't need to keep saying the said. Maybe say it once or twice to start with, and then just drop it. You don't need to do it. You don't need to keep using that. Another one I would talk about here is making calls. And again, MacPhail, why is it I love that book so much? MacPhail at chapters 977, 978 refers to these things as well, calls. I don't think I've ever, maybe I've made one or two. I generally never make calls in pleadings. And the reason is I don't see what they're for. What some people use them for is to draw attention to a weakness in their client's case, in their opponent's case, rather. The defender is called upon to vouch his having challenged the adequacy of a service or something that's important. In other words, you haven't done something, so you're called upon to do it. Now, to my mind, all you're doing is drawing the opponent's attention to a weakness. And generally you shouldn't do that, because all you're doing is putting the opponent on notice of a weakness which he can then try and correct. Why on earth would you do that? You're better off letting the weakness remain and then taking advantage of it at the later stage of proof or debate or whatever it happens to be. So making calls, I think, is generally a bit of a pointless exercise. I've seen these things abused as well. There used to be a lawyer in Glasgow many years ago who was quite elderly, and everybody indulged him and humoured him just because of his age and because he'd been around as long as anyone could remember. But at the same time, they never really took him seriously, and one of the reasons was that he used to make calls such as, if say he was defending a case, he would make a call along the lines of, the pursuer's agent is called upon to dissociate himself from his client's outrageous accusation that the defender failed to supply goods of satisfactory quality. That's the kind of thing he would put in his pleadings. It's just a ridiculous thing to put in, but he would do it a lot, and he would do it in oral submissions in court as well. He would call upon you to disassociate yourself from your client's position. It's just silly. Now, I don't think anybody thought that was appropriate. But that didn't stop him. But that's a kind of extreme type of call, a lot more so than the type I've mentioned about calling upon your opponent to explain something or vouch it or do something of that nature. But generally speaking, I try and avoid calls, and I would suggest you do the same. So I'm kind of getting towards the end of my talk. I don't really have much left here to say. I think all I would say, I suppose, is we started this discussion about debates and about the changes that there have been over the years and how courts approach written pleadings. You have to have regard to that. I think these days there are plenty of cases now that don't go to debate that would have gone to debate a few decades ago. And if you are in a position where you're thinking about taking a case to debate, then ask yourself, is there really any point in it? Quite often there really isn't. Quite often there's actually an advantage in going to proof where your opponent's pleadings are a bit defective. As long as it's not causing you prejudice, sometimes it can be quite advantageous. So don't bother going to a debate unless you think you've got a really good point, something as well that would be hard for your opponent to put right. And try and save time, try and save cost. Don't waste time on having futile arguments about pleadings when there's not really any underlying point to it. That is in accordance, in my opinion, with the direction of travel in which the courts are currently moving. Where as I said, with reference to that case, what was the case called? The Ahmed case, the one in the Court of Session in the summer there. You don't automatically get a debate. Courts are now looking with more care and caution as to whether or not pleadings are such as to justify debates. We're moving in a way now that things are being standardised. Written pleadings are being standardised. Civil online, I think, will move out into all areas of litigation. That will lend itself to standardised writs and defences, and that in itself will diminish the importance of pleadings in general. It won't completely get rid of them, of course. There'll still be a need for good written pleadings, but I don't think in future they're going to be as important as they have been to date. I think there's a general, I wouldn't say dumbing down, that would be unfair, but I think there's generally a de-skilling of all kinds of legal work. It's the same in conveyancing, and it's just the way that things are going now, and we have to recognise that. As I say, the courts are there to serve the public, not lawyers, and we have to remember that. So I hope that what I've been speaking about for the last 2 hours, at least some of it, has been helpful. And if you have any comments or any questions or any sort of feedback, then I'm more than happy to hear from you. So the best way of getting in touch is probably just by emailing the Scottish Law Agents Society, and if you do have any comments or feedback, please let me know. And without further ado, I shall bring matters to a conclusion, and we're almost at the 2 hours. I don't know if you've been able to watch this in one sitting. I suspect not, but that's okay. I understand. Some of this can be quite dry, but the beauty of this format is that you can dip in and out of it as you wish, and it may be that that's what you've done. So, as I say, I hope you've enjoyed the talk or found it useful. I'm Andrew Stevenson, Solicitor Advocate, Secretary of the Scottish Law Agent Society, and I will bring matters to a conclusion